Hi students, how are you? Sat Sri Akal. Let's discuss the topic of restitution of conjugal rights in Hindus in India. So as far as Hindus in India are concerned, the restitution of conjugal rights remedy is given under section 9 of Hindu Marriage Act 1955. What is restitution of conjugal rights? Before knowing this, we should know what is conjugal rights. Basically, conjugal rights are rights of a husband over his wife and rights of the wife over his husband. Just because of the fact that they have been married now, they are in a matrimonial relationship, there are certain rights of husband over his wife and wife over his husband. Both are having certain rights over each other, and those rights are known as conjugal rights. And what is restitution of conjugal rights? Bringing back those rights either by the husband or the wife through the help of the court. For example, if the wife has left the husband without any reasonable cause, then husband can file a suit in the district court of restitution of conjugal rights. That is, he has a right of the society of the wife. She has left him without any reasonable cause, and he will pray to the court that please pass an order compelling her to come back to the matrimonial home because she has left my society. I need her society because she is my wife and I am her husband, and she needs to perform certain conjugal duties for me. I have my own conjugal rights. To please restitute my conjugal right. She has left me without any reasonable cause. Similarly, if the husband leaves the society of the wife, then wife can also file a case in the district court of restitution of conjugal rights. She has certain conjugal rights and husband has to perform certain conjugal duties. So please bring back my husband. She will pray to the court to pass an order compelling the husband to come back to the matrimonial home, or wherever he is living, he should take the wife along with him. They should live as a husband and wife because the purpose of the marriage was this only. What is the purpose of the marriage? To live like a husband and wife happily in a conjugal relationships, to have kids, to enjoy life, to perform marital duties, to enjoy the comfort and society of each other. This is the only main aim of the marriage now. And if this aim is not being fulfilled, then what is the purpose of marriage? What is the usefulness of marriage? So court assists in this thing. Court want to preserve the marriage. Court want to preserve the marriage. That's why the court passes the decree of restitution of conjugal rights, and law wants that the institution of marriage should be preserved. Though there is a provision of judicial separation and divorce in Hindu Marriage Act, that's a different thing. But even now also court always tries to preserve the institution of marriage. That's why this decree of restitution of conjugal rights. Even there is a case of Saroj Rani versus Sudarshan Kumar Chadda, year 1984. Very important case. In this case, the Supreme Court noted that the essence of marriage is the sharing of common life between husband and wife, a sharing of all the happiness that life has to offer to both of them, and all the misery that they have to face in life. So this was the very important case in which court dignified the institution of marriage. Now, the thing is, if there is a reasonable cause, here the main thing is, if there is a reasonable cause for the party, for the respondent to leave the petitioner. You see, that court has to see. You see, the main thing is, court will grant the restitution of conjugal rights decree to the petitioner only if there was no reasonable cause, there was no legal ground for the respondent to leave the society of the petitioner. But in case the respondent appears before the court through his advocate and he proves to the court that there was actually a reasonable cause for him or her to leave the society of the petitioner, then the court will inquire into that reasonable cause. And if court comes to the fact that there was really a reasonable cause for the respondent to leave the society of the petitioner, then court will not grant a restitution of conjugal rights decree in the favor of the petitioner. Obviously, that reasonable cause may be that, for example, if the wife has filed the petition of restitution of conjugal rights against her husband, and husband comes to the court and says that no sir, the thing is that I have left her society because she continuously tortures me, she beats me. Obviously, but normally it's the husband who beats the wife, not the wife. But in some cases, exceptional cases, there can be certain facts like this. So she beats me, she's an alcoholic, she ill treats me, she ill treats my mother and father, she mentally tortures me, blah blah blah. There may be many things according to the facts and circumstances of the case. So if really this is the thing and this has been proved by the evidence given by the husband, then court will not pass a decree of restitution of conjugal rights in the favor of the wife, because wife here is wrong. She cannot take advantage of her own wrong. It is because of her own wrong, own fault, the husband has left him, and now she is filing the case of restitution of conjugal rights. No. Similar is the case when the wife leaves the husband. Generally and usually also, this is the main scenario in India. If the wife leaves the husband without any reasonable cause, then husband files a case of restitution of conjugal rights in the district court and pray to the court that please bring back my wife to my society. She has left my society. I need her society, and without any reasonable cause she have left me. But in case wife appears before the court through her advocate and she proves to the court, no, I have not left him without any reasonable cause. There is actually a reasonable cause for me to leave my husband's society because he is continuously ill-treating me, he's beating me, he's physically torturing me, he's mentally torturing me, he always taunts me of bringing less dowry, he continuously hit me, beats me to bring more, he pressurizes me to bring dowry. So all these things can, basically this is cruelty. And if she is able to prove all these things, then obviously husband will not get decree of restitution of conjugal rights in his favor. It can be the other way also. The wife on these same grounds of cruelty can file a case of judicial separation and divorce on the same husband who has filed the case of restitution of conjugal rights. So on the basis of those reasons, the wife can also file a case of divorce or judicial separation against that husband, because there was really a legal ground for her to leave the society of the husband, and on the basis of that cruelty, that legal ground, she can file a divorce case and even she can get maintenance from the court. तो ये तो उल्टा पड़ जाएगा. हस्बैंड ने रेस्टिट्यूशन ऑफ कन्जुगल राइट्स का केस डाला, लेकिन वाइफ डिवोर्स का केस डाल रही है. तो यूजुअली ऐसे ही होता है. ठीक है. सो इट कैन बी आइदर वे. फैक्ट्स पे डिपेंड करता है कैसा केस है, तो कोर्ट की डिस्क्रिप्शन है कैसा करना है कैसे नहीं. बट अगर वाइफ ने डिवोर्स क्लेम करना है, देन शी हैज टू फाइल अ केस फॉर डिवोर्स ऑन द सेम ग्राउंड्स. ठीक है. क्योंकि क्रुएल्टी के ग्राउंड पे वो छोड़ के गई है. अब वो कह रहा है कि मेरा रेस्टिट्यूशन करो, उसको वापस बुलाओ, कोर्ट की हेल्प ले रहा है, लेकिन वो प्रूव करने को तैयार है ना कि मैंने इसका घर इसलिए छोड़ा है क्योंकि ये मुझे मारता है, पीटता है, डॉरी के लिए तंग परेशान करता है. तो ये सारी चीजें अगर प्रूव कर गई कोर्ट में, तो ऑब्वियसली हस्बैंड को डिक्री नहीं मिलेगी. वसेवे की, इसको कहते हैं वसेवे का केस, पंजाबी में कहते हैं वसेवे का केस, तो उसको रेस्टिट्यूशन ऑफ कन्जुगल राइट्स की डिक्री नहीं मिलेगी. तो दिस इज द थिंग. देन there was a case of T. Sarita versus T. Venkata Subbiah, AIR 1983. Very important case. In this case, it was argued that Section 9 जो है Restitution of Conjugal Right Decree, it is against the fundamental rights of liberty. It is against the fundamental right of life and liberty under Article 21 of the Constitution of India. It is against the privacy of a spouse. How can court compel the spouse to come back to the other spouse, to join the society of the other spouse? How can court compel the respondent to join the society of the petitioner? For example, petitioner is the husband. How can court compel the wife to join the husband's society if she does not like him, she does not want to live with him? It's not that he is beating her or something like that, but she does not want to live with him. She does not like him. There can be any cause. It's her own sweet will whether to live with the husband or not. It is her own privacy. It's her private matter. How can court compel her to live with him? No. Obviously, the husband can file a case of divorce against her, but court cannot compel the wife to live with him. It's their internal matter. It's her privacy. So this is violating her privacy, right to life. So this under in T Sarita case, Supreme Court this no, not Supreme Court, this Andhra Pradesh High Court held that this Section 9 is unconstitutional and void. So this was the ruling. But this was in 1983. But in 1984, this case was again. It was again coming before the Supreme Court, and the case name is Saroj Rani versus Sudarshan Kumar Chadda, 1984. So in Saroj Rani versus Sudarshan Kumar Chadda, 1984 Supreme Court, finally this question was settled. The main tug of war, main conflict between Section 9 of Hindu Marriage Act, that is Restitution of Conjugal Rights, and the fundamental rights, this tug of war, this conflict between fundamental rights and Restitution of Conjugal Rights has been settled in the Saroj Rani case by Supreme Court, and Supreme Court has held that no, we are not compelling the wife or even the husband to have sexual intercourse with the other. No, it's their private matter. We cannot compel through the court decree. No, but we want to preserve the marriage. Court is there to preserve the institution of marriage. We cannot force the unwilling wife to engage in sexual relationship with the husband. No. The remedy of restitution only aims to protect the institution of marriage. It does not violate the principles enshrined in Article 14, 21 and even 19. So we are not enforcing sexual intercourse between husband and wife. We only try to bring consortium between them. They should live together as a husband and wife. They should live together happily as a husband and wife. And if one of the spouse leaves the society of the other spouse without any reasonable cause, then obviously why he or she married him or her? There is no purpose of marriage then. They have married to live together as husband and wife. So obviously that's why court passes this decree, but court will not look into their private matters. It's their own sweet will whether to have sexual intercourse or not, but court will preserve the marriage. So this was the reasoning given by the court in Saroj Rani case. Then recently there is a important case of Ojasva Pathak versus Union of India 2019. Ojasva Pathak versus Union of India 2019, very important case. In this case, what happened? There was a writ petition filed in the Supreme Court against Section 9 of Hindu Marriage Act, Restitution of Conjugal Rights. And the main contentions of the petitioner were that this restitution of conjugal rights provision or remedy goes against the wife's autonomy, because it obliges her or makes her legally bound to return to her husband even if she does not want to return to him. Even if she is not wanting to return to the husband, court is compelling her to return to her. So this is not right. The second condition is that it is her private interest whether to have sexual intercourse or sexual autonomy or not. How court can compel her? How court can compel her to return to the husband and have sexual intercourse with the husband? No, it is her total private interest and it's his sexual autonomy. It's her sweet willness. It is her willingness. How court can compel her? Then the other is the same thing. You cannot compel the spouse to have unwanted sexual intercourse, because that will violate Article 14 and 21 of the Constitution of India, right to life, right to privacy, everything. Now this case is pending in the Supreme Court. It is res sub judice. The last date of hearing was 8th of July 2021. It is still pending. Court will decide the matter in future. I hope court will decide the matter by keeping into view all the pros and cons of this thing, all the contentions of the stakeholders, all the contentions of the petitioners, and even the respondents, and general viewpoint also. The court will decide the matter finally. I hope the law will be settled on this matter. Whether this provision should be there on the statute or not, the court will decide. In Ojasva Pathak case, still it is pending in the court, so we should not comment on the pending decision. It's res sub judice. But besides that, we should also keep in mind one more point, and even the Supreme Court also will consider this, that even in India now also, the marital rape by the husband over the wife is not an offense. If the wife is adult, husband is also above 18 years, and the husband is raping his wife, that is marital intercourse, marital rape, not intercourse, marital rape, that's not an offense. What's the rape? What's rape? Rape is sexual intercourse without the consent of the woman. If there is no consent, then that is not sexual intercourse, that's rape. But if the husband commits this thing, it's not an offense. So this should be cleared. And if marital rape is not an offense in India, through restitution of conjugal rights, you are compelling the wife to go to the husband, and then obviously husband can have his free say. He can commit marital rape. Now this is also against Article 21 of the wife. This is also against the right to life of the wife, right to privacy, right to life, right to dignity, dignified life. And even in the case of Joseph, that case is Joseph Shine case is relating to adultery. But in this context also, it is very important. In Joseph Shine versus Union of India 2018, the Supreme Court held that adultery is not offense in adultery is no more an offense in India, and the wife has its own autonomy, dignity, and privacy. She's not the property of her husband, and husband is not her master. Women have equal status in the society and should be given equal opportunity to put their own view forward. So how can you compel the wife to come back to the husband, and if the husband is committing marital rape, then that's not an offense. So obviously you are not taking into viewpoint the rights of the wife as such. Article 14, right to equality. So all these things has to be kept into mind, and obviously Supreme Court will keep into mind while deciding this case, Jasper Pathak case, whether Section 9 should be there in the statute or not. So let's see what the court will decide. And I hope you like this video. Do comment on the video below so that I can learn from your comments, your precious comments, so that I can upload more and more videos on the similar topics. Thank you. Sat Sri Akal.